Hello, I am Bligma269 and this is the Restrict Act. This has been a big topic that's been talked about a lot in like YouTube, social media, so on and so forth. And I have seen a bunch of videos on it, I have read up a bit on it and like seen content you have made of it. And I want to know more. I have not understood everything it actually involves. I have heard about what people speculate are its impacts. I understand that it could do, for instance, one people talk about a lot is banning TikTok, stuff like that. So it can do a lot, but I don't really know the specifics of the bill. So I want to actually read the bill itself and understand what it actually does. Now, this isn't really me giving my political take on this or whatever. I don't really care. I'm not American, like it doesn't matter. But I want to understand what it does because it seems very interesting and it seems like it's in like an area that is of interest to me. And so far, the content I've seen on it has raised my interest. So I'll just read this shit and try to understand. Now, one thing is, I'm not a lawyer. I don't know shit about the law. I don't know shit about the US. I don't know anything. So please don't take anything I'm saying as truth. Because it is not. It is me and my interpretation of this. And especially given how law can be written sometimes a bit vaguely and so on, I might make interpretations that are incorrect or inaccurate or different from the intention. So just keep that in mind. But anyways, I'm going to read through this shit, try to understand what it's about, and just try to talk about what it actually is. And yeah. Let me get started. So first of all, we can see here, this is an important thing to note, is it hasn't actually passed yet. So actually on top of the site, we can see like the actual actions and like where it is on the political like process. So there's the last thing happened was on 7th of 3rd, so like a bit over a month ago, and we can see it's been read twice and referred to Committee on Commerce, Science and Transportation. So it's currently not like law or anything has been given to this political decision body to read, I guess. And then it has this stage, you can see it's only been introduced so far. So it hasn't passed the Senate yet, it hasn't passed the House, it hasn't passed the President. So it had to first pass the Senate, it will have to pass the House, and then be, I guess, approved by the President. If that's how the system works, in order to become the law. So it's not like the law yet, and I think some of the content I've seen doesn't really make this clear that it's, hey, it's not there yet, it's not a real law yet. It's just in the process of being like discussed and figured out. It could become the law though, and I think that's why it's so hot. Like the fact that it is like in consideration is what's making people so talking about it, I guess, because it is divisive, clearly, given the strong opinions I've seen. But anyway, let's actually start reading this shit. So first of all, they have a summary page. So this is a summary of what it does. I'm going to read the actual bill as well, because this, I already looked at this a bit. It doesn't tell everything, but I should read it like properly to understand what this says. So, restricting the emergence of security threats that risk information and communication technology act, or the Restrict Act. Yeah, this Restrict Act is a lot shorter than the whole thing. It's fine that they take like the first word and then just like make that the acronym. But yeah. Or I mean, it is like from the words, but the fact they word each shots at the first word would basically be the acronym. It's fitting, I guess, of what it does. So it's only one summary. It is authorized, I think, because it's on the official site for Congress.gov, so it should be like fairly accurate on what it's talking about. So this bill requires federal actions to identify and mitigate foreign threats to information and communication technology, products and services. For example, it is social media applications. That's where like TikTok and stuff becomes in talking, and why those are referenced here. It affects social media stuff, and that is a very popular social media application. And later down here, we have such as China, thus linking TikTok into being relevant. Anyways, it also establishes civil and criminal penalties for violations under the bill. I'm still not sure what these actually are. That's one of the parts why I want to actually read the bill, because I don't know what it actually does. Like, I don't know what the consequence. I don't even know what the violations are. I don't know if they're even specified. I hope they are, so I'd actually understand something, but it's unknown for now. Anyway, specifically, the Department of Commerce must identify, deter, disrupt, prevent, prohibit, investigate, and mitigate transactions involving ICT products and services in which any foreign adversary, like China, as mentioned before, has any interest and that pose an undue, unacceptable risk to US national security or the safety of US persons. Once again, I hope the actual bill gives more details on what the actual like risks are, what they actually mean by this, because this summary is really vague about it. And if it's only this vague, it means they can basically apply it to whatever they want, which could be a problem. But we'll have to read the actual bill to know that. Anyway, additionally, Commerce must identify and refer the President any covered holding, stock or security are examples of this that pose an undue and unacceptable risk to US national security or the security and safety of US persons. If the President determines that the holding poses such a risk, the President may compel this divestment or otherwise mitigate the risk associated with the holding. So basically, if there's some stock, I guess they have to like go ask the President to decide on if it's actually a risk or not. I don't know. Commerce may designate any foreign government or regime as a foreign adversary upon determination that the foreign government or regime is engaged in a long-term pattern or serious instances of conduct of single adverse to US national security or the security and safety of US persons. So basically, I guess what this says is, okay, if Commerce decides, once again, like a vague, if they decide that it's like adverse to US, if it's like harmful to the US, if it's harming the interests of the US, either in terms of the government or the people, then they can apply. They can make, okay, you are an adversary. You are an agent affected by this bill. So they can do that, and then they can remove that as well. So if they decide, okay, it's actually not an adversary, it's not actually not bad, so then they can go, okay, remove it if they want to. Commerce must notify Congress before making removing a designation. So they need to like tell Congress about it. They can't just like do it silently. And the Congress can disapprove it, I guess. So it is like there is a boy that can like say no, you're wrong. Apart from the Commerce directly. And the bill outlines enforcement mechanisms, including action by the Department of Justice and civil and criminal penalties. So I guess we'll get to understand the penalties somewhat. And then how they actually intend on enforcing it, what the actual means of doing it are, and so on. So that's the summary. Now let's actually try to understand what that means. So here's the actual bill, the text of it. It's a bunch of length. Once again, I'm not a lawyer. I don't really know everything necessarily, but I'll try to understand it a bit. And yeah, so well, first of all, we have here just like the people involved, whatever. Yeah, so I think this is too important, but yeah, so this is like prohibitions for transaction between persons in the US and foreign adversaries. So immediately you can see to operate cyclical cost to review and prohibit. So the Commerce Secretary can act like the bill states that it is a person. It's like they have said it's only aimed at like corporations, but it is stated persons here, so it could be about people and how people act. And unless they specify somewhere here that okay, it's only corporations, it does mean that individuals could be affected as well, even if they aren't. Like there is the bill could technically be enacted for those cases, but I should read more before I understand, because I don't actually know if they mentioned that or not. And they mentioned that it's called Restrict Act and definitions in this act. Classified national security information. So that means information that has been determined pursuant to executive order 35526. So some like executive order defines what this is, or any predecessor or successor order. So basically, if this changes, it says okay, that will also be applicable. Trigger project is unauthorized disclosure and is marked to indicate that's a safe in documentary form. So I guess it's information that, okay, you can't, it's classified information. You can't talk about that. Controlling holding. So that means a holding with power, direct or indirect, and exercised or not exercised to determine direct or decide important matters affecting the entity. So yeah, that's just holding. They're holdings. Now covered holdings means that like according to this, regardless of how or when such holding was or will be obtained or otherwise come to have been held, a controlling holding held directly or indirectly in an ICTS covered holding entity by so it's okay if it's ICTS covered holding, but it has to be covered by a foreign adversary. Oh, it has to be held by a foreign adversary, an entity subject to jurisdiction of the laws of a foreign adversary, or one that's owned or controlled by an entity described in the first and two. So if it's like something like under like a entity, so if it's like, okay, how like a company that's like a foreign entity that works, if it's a company that functions under like foreign laws of such a country, that's counted as anniversary, that counts. And also if you have like a sub, I guess like a sub company under that would also count. So I think that's what that means from what I'm understanding. Includes any other holding, the structure of which is designed or intended to evade circumvent the application of this act. So if they're trying to evade this, I guess they apply it anyway. In general, the term, I don't really understand what holding refers to though, so I'll just like stuff they have, I guess. Maybe like stocks and stuff that's mentioned in summary. Anyway, I'm not sure though, so check on that, double check on that. Includes any other holdings, blah 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 that I read. Covered transaction. In general, term covered transaction means transaction in which the entity described in subparagraph B has any interest including through an interest in contract or the person taken to service or any class of such transactions. So if one of these entities, so once again the same ones like with different adversaries, if they have any interest in the transaction, then, which I presume is this is to be used later, then that's what a covered transaction is. So they have interest in doing that. Non-evasion. Any other transaction, once again, if it's hard to do to evade it, mentioned again. And timing. The term covered transaction equals current, past, or bunch of future. So they are also basically, okay, if something's done something in the past, we are also applying that here. So it's like YouTube when they, you know, change something and apply it retroactively, like these also apply retroactively, it's done in the past as well. Anyway, the term critical infrastructure has the meaning given in the term in section whatever of the USA Patriot Act. I don't know what that is, so I won't know, and I'm not going to read it. Entity means any of the following, whether it's coming in the United States or to the States: a firm, a government, a labor union, organization, a partnership, a trust, a joint venture, a corporation, a group. Okay, so if you say entity, they do mean like companies and unions and etc. So it's not like saying it's an individual. So they do mention like it has to be within a company or some sort of unit. But some of these are also quite vague, so how they actually would apply it, and technically people are technically part of like companies and part of like organizations when they work and stuff, so does it count for that? Does it not? That's once again a bit of a question. It's not unclear, but so far they have specified, okay, it relates to these kinds of entities. Fair enough. So let's see what actually implies though. Executive Department Agency, so that has to mean given, okay, some other law that I don't know about. Okay, so any foreign government or regime determined by Secretary due to sections 3 and 5, which we probably go to later, they have done like this once again, like certain instances or patterns of conduct that's like adverse to security or their people, and includes and removed the people to China, okay, including Hong Kong special administrative region and Macau special administrative region, Cuba, Iran, Korea, Democratic People's Republic of Korea, that is. So you know, yep, and the Russian Federation, so Russia makes sense. It's quite hot with Russia right now, and the Bolivarian Republic of Venezuela. So Venezuela, and holding means it could interest stock. Okay, so it means what holding actually is for the earlier parts here. So it could interest a stock, security, a share, a partnership interest, an interest in a limited liability company, a membership interest, or any participation right, or a equivalent power distinct to any structure, and includes without limitation any security convertible into an ownership interest and right, a warrant or option to acquire ownership interests. Okay, so it's basically like stocks and shares and so on and so forth, and partnership stuff. Any stuff like this is counted as a holding, so it is affected by the bill as well. And I just covered holding entity. We say that owns, controls, or manages information and communications technology, that's services. Okay, so companies and stuff that actually manage that. Has not less than a million US state active users. So preceding data which the covered holdings referred to the president. So if it's like big enough with the users, for which more than a million users is sold to persons. So like it has to have like a million users to be considered such an entity. So it's just big enough basically. Like a tiny thing wouldn't count as a IC discovered holding entity. It's only bigger ones that are counted as such. Mitigated measure. So it's meant just like an agreement with any party and the government, or ordered by the government, and of which the party has been informed in anything like mentioned in this to address any risks. And yeah. Then person, it means a person, including like an individual. And relevant is the permanent assets. The permanent assets means the different positions of these like different agencies and departments and so on. Relevant committees. Yeah, committees that happen to be relevant or considered as such. Secretary means secretary. A transaction of commerce in this case. Transaction means any acquisition, importation, transfer, installations, like transaction about some product or service. So yeah, that means that. Okay, so now section 3, addressing information and communication technology products and services that pose undue or unacceptable risks. Okay, so I guess it will like talk about the details of like how do you define what product means risk. So the secretary, in consultation, like consulting the relevant department, and its heads, so whatever the heads happen to be that are relevant, can identify, deter, disrupt, prevent, prohibit, investigate, or mitigate in some manner, including negotiations, entering into or imposing and blah blah, enforcing, like any measure to address these risks of transactions by any person. So it's like about persons here, not about like companies, just any companies, any person, such jurisdiction of the United States that secretary determines pose an undue actual risk of sabotage or subversion of the design, integrity, manufacturing, process, blah blah blah, of taking a price service in the US States. Okay, so now we have part. Okay, this part involves an individual person, so an actual individual could be affected by this. Catastrophic effects of security or resilience of the critical structure in the United States. So, you know, if they are sabotaging the design of stuff in the US, or they are having a catastrophic effect on security of the infrastructure or like digital stuff, then hey, it can also be deemed that interfering with elections. Fair enough, if they are like affecting elections, then they can also rule it. But how do you define interfering elections? Like, do you talk about, do you mean like speaking opinions on a platform? Do you mean change the election? What do you mean? So it's like, it could once again be used to be more vague, but fair enough. It's about preventing the whole, like, don't allow outside influence, I guess, on the elections. Let our elections be what we deem fair and whatnot. But once again, so far, this is just like if secretary determines this. So this all according to what the secretary can decide. So it's all up to the interpretation of what secretary deems unacceptable. So that's just worth keeping in mind. It's not like an objective, like on some like set criteria. It's okay, if the secretary decides this is too much risk, then it happens. And coercive or criminal activities. So if it's like criminal or coercive, once again deemed by secretary. Or actually legal is more specified, but coercive, once again we get the whole secretary thing. And yeah, so meant to undermine I guess the stuff in the US. Yeah, regulations, decisions, institutions, processes, to favor the adversary, and that harms the national security of the US. As determined in coordination with the Attorney General, the Director, blah blah. Yeah, so, or if you otherwise pose an undue or unacceptable risk of security of the United States. Okay, so basically anything. If the secretary decides they want something to be adversary, like if they deem it too risky, for whatever reason, like it can be one of these, but it can also be anything else. So anything that they deem that is like too dangerous, they can decide, okay, that's an acceptable risk, and that's affected. Okay, so let's move on to the procedure. Let's understand how this actually do. So no later than 180 days, so half year, after the date of enactment, the secretary, with the consultation of the agency heads again, shall review any transaction described in subsection A. So this was here. So if it's determined, then they need to review that, and then no later than, once again, that half year, like after the date on which it started, if it is deemed to have the risk, once again after it's been like consulted and reviewed, then it will qualify as a covered transaction. Or no, if it does that and it qualifies as a covered transaction. So if it's one, it's risk, and if it covers the unqualified covered transaction, and then yeah, so you're defining, okay, if it actually does that and if it's a covered transaction. And with respect to transaction fund, depose an undue or external risk and qualify as covered transaction. Determine whether the countermeasures should be prohibited or any other should be taken to mitigate the effect. So if it's covered as a covered transaction and it's deemed to be the risk, then they decide what they should do. Should they just ban it? Should they take some different kind of action about it? So it's about what they should do. Then publish explanations. So if practicable and consistent with the security and law enforcement interests of the United States, in coordination and cooperative with international agents, the Secretary shall publish information in a declassified form to explain how a covered transaction that the security denied or otherwise mitigated under paragraph 1 misconstrued business, blah blah blah. So basically, if they do this, they decide, okay, it actually does that, then they need to like publish it. No, if it's in their interests. Yeah, so they need to, like, if it's like in line with the interests, then they need to publish information on it. So it is like cover how it meets, like that, how it's like a covered transaction, how it's an unacceptable risk, and yeah. And then it talks about some US code that shouldn't be applicable to this. So then we get into section 4. So addressing information coming to you, blah blah blah. That so not just about holdings, so like the stocks and this stuff. So in the third one, it's talking about the actual products and services. That's like about the like holdings, like yeah, it's like about the holdings like stocks and so on. So once again, if the secretary determines with the consultation that these pose a risk, then they go to the president and they can decide on that. So procedures that refer so they need to establish procedures by which they shall conduct reviews of holding to determine if it actually constitutes covered holdings that pose such a risk, and they need to refer to the president. So they need to first review it, like to see, okay, is this like a risk, and then they need to also like ask the president, okay, is this valid? Do we count this? And then more to at any time preceding the issuance of regulations or establishment of procedures under the first one, the secretary can once again go to the president, refer to the president a holding determined to be covered holding under subsection A. Okay, I need to read this again. At any any time preceding the issuance of regulations or establishment of procedures under subparagraph 1, the secretary may identify and refer to the president a holding determined to be a covered holding under subsection A. So if it's determined as a covered holding, and you know, yeah, if it's determined as that, and then they can like refer to the president, and if the secretary holding subsection A for no, the president holding section to be covered by holding under subsection for A for any action pertaining to section C. If the secretary in the sole and under the discretion of the secretary determines that such referral would be in the interest of the secretary. Okay, so basically the secretary can decide, yeah, I'm going to give it to the president, so they can just like decide to do that. Then administer procedure requirements inapplicable. So subsection blah blah blah. You have the sets code shall not apply again, like stuff I don't know about. And the president needs to subject to section 13, which we'll get later, with respect to any covered holding referred to % or subsection A. If the president determines the covered holding pose an undue or unacceptable risk to national security in the States or the security and safety of the United States persons, the president can take such action as the president considers. Okay, so if the president determines that it does actually the risk, if they like approve with that idea, then they take action as stating appropriate to company divestment or otherwise mitigate risk. So once again, like take action about mitigating what they view as risk and stopping it. Yeah, and then the holding is basically under their jurisdiction. And that is in respect to the United States corporation as such property of the entity in which the covered holding is held, or if any processors want to control this and blah blah by the entity are used in the United States. Any attachment municipal assets that are used or enabled to support the United States, and they obtained and derived from the use of products of the entity blah blah in the United States. So basically, any United States related stuff in the product, they can be mitigated, can be affected, can be changed in accordance with what the president wants. And on data law authority, so the authority to company divestment of covered holdings under paragraph 1 may only be exercised by the president and may not be delegated to anybody else. Okay, so basically only the president can actually do this. They can't say, okay, somebody else does this. Announcement: if the president determines that the action is required, then the president shall announce. They should not later than 30 days after the referration by the secretary. So after the secretary refers it, the president has to do it in 30 days. Yeah, so yeah, it needs to be done in a month from that. Enforcement: the president may direct the attorney general to seek corporate relief, including divestment relief, in the district courts of the United States in order to enforce. So yeah, it's just like, okay, enforce this somehow. Anyway, considerations. So the secretary needs to prioritize evaluation once again of these things. So information and communication technology products or services used by a party to cover the section in sector infrastructure and policy whatever. Software, hardware, or any other product or service integrated telecommunication products and services including well, like Wi-Fi, so the WLAN, mobile networks, satellite payloads, satellite operation control, cable access points, foreign access points, so like current trade systems, networks, it's computer platform. So basically like networking stuff needs to be a priority here as well. Any software, hardware, any other product, internet data hosting, or a computing service that uses process or retains, or exactly use process or retain system data, so system data with greater than 1 million people in the US. At any point of the year, impaired proceeding data on which the covered transaction is referred. So referred to. So yeah, like internet hosting services, code-based search, search, machine learning stuff, managed services, and consumer services. Mind you, that's just including list. It could also, I guess, include anything else. But this is what they give, so those things are affected. Worth keeping in mind. Like sensors, like webcams, surveillance devices, modems. If, once again, more than 1 million needs to be sold in the US. Or to people in the US, I guess. And any point during the year preceding to date in which it's given the secretary. Yeah, so that's that. Unmanned vehicles, drones and stuff like that. Software designed to be used to connect and communicate on internet. So internet online software is also affected. And it basically includes everything. Information communication technology, practice service integral to all of these things. So basically it's ICT shit. Like all kinds of technology things are being affected here. So yeah, it does include, that would include TikTok. It has enough users, it's big, it's fine adversary that's been determined, China. And yeah, so that would be affected by this bill, but not that much. In determining whether the characteristic implies an risk, the secretary shall determine appropriate and constitute appropriate discuss the where available and removal or exclusion order issued by a different secretary and authorities like secretaries and directors, etc. Any order or license revocation issued by the Federal Communications Commission with respect to the transacting party or any consent decree from the Federal Trade Commission with respect to the transacting party. So basically, if other like important parties decide that they want the exception, it's okay. Then I nature the likelihood of some consequence to public and private sector in the states that would occur if on the result of information and communication technology supply chain were to be exploited. So basically communicate like the consequences of issues with this like product. So like how bad would it be if TikTok lost its like leaked its data or whatever? And any other information that they need appropriate. So basically anything. It goes back to that like, okay, anything the secretary decides is appropriate can be appropriate. Then they also may consider any relevant threat assessment or report prepared by the Director of National Intelligence that they like request them to complete. And now to designation for an adversary. So how do we actually decide what those are? So once again, they can quit consultation of the Director of National Intelligence, decide anything as that. If they find that, okay, it's engaged in a long-term pattern of some instances of conduct that is adverse, so basically they decide it's doing adverse things, it has been for a long time, then they can do that. Removal of designation, so the secretary can, in consultation with them, remove this as well. So basically, it can just like decide, okay, it's no longer that. Then notice, not later than 15 days before date on which secretary makes or removes designation, they need to notify the president. Made sure in a manner of either Senate, so I need to notify the president and the Senate. The Speaker, material, House of Representatives, so House also needs to know. And around committees of Congress, once again, they need to be notified. So all these parties need to be notified in writing of the intent for designating or like removing them under this section. So so they need to like figure out they need to inform them about all the basis for it and the fact that it's been done. So it's just to inform. They don't need the like approval, but they need to like inform them. Resolution of disapproval of the nature of foreign adversary. So covered joint resolutions means a joint resolution of disapproval. Mission blah blah. Okay, let's not focus on this too much. I don't want to perverting that. Anyway, initiation. So in the event that the secretary designates someone as adversary or something as adversary, or removes that, a joint resolution of disapproval by their designation or a joint resolution of disapproval, blah blah. During the second period, the director shall be adopted be expected consideration per subsection. Okay, so they can make a disapproval resolution. Yeah, so they can like decide we disapprove on it. And it may be impeached by Senate, so the majority leader can decide, or the minority leader can decide, okay, look, we want to do that, and in the House of Representatives as well. So it can like, there can be expressive disapproval, I guess, from these parties. If a relevant committee of the House to which the card change has been referred to has not reported within 10 days after the parole, that then it shall be like, then it doesn't matter, I guess, anymore. Beginning of the first day after each committee to which the coverage research has been referred, the House may discharged from further consideration, blah blah. It shall be in order movement to proceed to consider the coverage resolution in the House. All points of order against the motion are waived. Such a motion shall not be in order after the House has to dispose the motion, proceed on the coverage resolution, blah blah. The previous question shall be considered as ordered the motion without intervening motion. The motion shall not be debatable, and motion reconsidered vote by which the motion shall not be in order. So they can't like re-vote if they like that basically like, yeah, then the covered trade resolution shall be considered spread. So once they have like read it, it's considered spread, and all points against it and against it are waived, and then it will pass, I guess. And yeah, it can't be like reconsidered. Yeah, so if they don't consider like that disapproval, then they are like considered. Yeah, so I'm not reading this. So yeah, they can basically read on that, vote on passage, and if they vote it, then the chair rules on it. I'm not too interested in this part, to be honest. I won't read too much of it. Okay. Okay, so basically, yeah, if they disapprove, it just means they are not actually considered for negative research. They can like say, okay, we don't want to be that, and then it can be that. So if like they vote that it's they fail that, then it can't change. Yeah, so if they like appoint or disappoint or like remove somebody as that, then like as for an adversary, they can vote against it and basically say, okay, so we don't want this to be the case, we disapprove with it, and then it won't be the case anymore. Regulations, the Secretary may establish rules, regulation procedures as they consider appropriate. So they can take action to individual anti-classes. So they can like give opinions and procedures to carry out the act. They can carry the list of like different persons that can be subject to these restrictions, and they can undertake any other action as they feel they need to carry out responsibilities. That isn't like otherwise illegal, so they can't go and like do illegal shit, but you know, they can decide on stuff. And they can appoint like advisory committees in order to like help them out in carrying out this act. And in general, the Secretary may require any party to transaction or holding a review to investigate present this act to furnish under oath. In the form of reports or otherwise, any time may be required by Secretary to complete information related to any act, transaction, or holding subject, so they can like ask for information. Authority, so they can require information or reports submitted under subsection to include the production of any documents relating to any act, transaction, or party related to transaction or holding blah blah blah. And so they can require that they get information. Then they can require information to be submitted during after. Basically, saying like when they need to report information. They can also do conduct investigations, hold hearings, administer oaths, examine witnesses, receive evidence, take depositions, and require subpoena, attendance and testimony of witnesses, and the production of any documents, red transaction, or holding under review or investigation, regardless of any report has been recorded or filed in connection. So they can ask for conduct investigations and stuff like that. Then format. So any person producing any document or secretary present this section shall produce document in a format usable to the Department of Commerce, which may be detailed request of document or otherwise agreed by all the parties. So in general, any information or document not authorized public request available has been decided the Secretary of this Act shall not be released publicly except to the extent required by federal law. Disclosure, notwithstanding the first one, the Secretary can disclose information or documents that are not otherwise public in these circumstances. So yeah, they, like documents are not to be published, but they can be published in this situation. So if portion to administrative or physical proceedings in condition of Korea 12, so you know if the document is that, then that. If portion to an Congress, if portion to a request from a relevant committee of Congress, so the Congress committees can request for it to be public. The federal state or local government entity or so on can also do that. And if the parties to hold the information or documents pertain consent, so disclosure, if the Secretary determines that it is in a change, so once again the Secretary can decide, hey, I'm going to release information. So once again, there's a statement here that the Secretary can basically do what they want. And any other purpose authorized by federal law. Yeah, so basically anything. Like, they're just fully going on that. How long is this anymore? Okay, I think we are not reading all the bottom stuff, so it shouldn't be too long anyway. Going back to enforcement. So, investigations in general, they shall rely on, including by delegation, secretary, and the heads of the federal agencies, as appropriate to conduct investigations of violations. So, yeah, they are like secretary and federal agency heads are going to deal with the whole investigations, the mitigation measures, enforcement, regulation, everything. Acts by the signees, so in conducting investigations, so once again, one secretary or the heads go to do investigations. The signed officers or employees described may, to a necessary extent, big term again, or appropriately to enforce this act, exercise such authority as is conferred upon them by any other federal law, subject to policies and procedures approved by Attorney General. Then permitted activities. Officers and employees agencies authorized to conduct investigations under subsection may So like the previous ones, if the default allocated are doing that, they can inspect certain tendencies or impose denial orders with respect to items in any form or condition to believe that these items have been. There are items that have been or being or about to import in states in violation of this act. So if they are deemed dangerous, I guess, requires inspect obtained books, records, and any other information from anybody. Administer all the informations and advise upon and require any person to appear and testify. It's just like about how they can like ask them to come and give witnesses, they can ask them to give them items, they can do the investigations this way. Obtain court orders and issue legal press to extent authorized under these chapters. Or under any other law. So basically under anything. Like any existing laws. Enforcement subpoena, so in case of contumacy by a refusal to obey a subpoena issued to any person under subsection, so B3, this one. A district or court of the United States, after an unjust person, a hearing, has jurisdiction to the issue, so the court can have the jurisdiction to issue an order requiring them to appear and give testimony, or to appear and produce books, records, and other writings that are subject to of the subpoena. So any failure to obey that can be punished by the court as a contempt. So fair enough. Actions by the Attorney General. So the Attorney General can bring an action in an appropriate district course. So appropriate relief, so they can call it to be in court, I guess. They include the declaratory and injunctive or divestment relief against any person alleged act or any regulation or direction, so they can call like court. Attorney General can call like people to court for these things. There are some limitations done, but yeah. An unlawful act. So in general, it should be unlawful for a person to violate, attempt to violate, conspire to violate, or cause violation of any regulatory order, direction, mitigation measure, prohibition, or authorization of a directive issued under this act, including any of the unlawful acts described in paragraph 2. And yeah, so penalty specific unlawful acts. The unlawful acts described in paragraph following. No person may engage in any conduct prohibited by contrary or refrain from engaging any conduct required by any regulation or measure, prohibition, or authorize or device a directive issued under this act. So nobody can do what's prohibited here. Nobody can cause aid, abet, counsel, comment, blah, blah, permit or approval of doing any act prohibited by the omission of any act required by regulation. So once again, I just can't produce stuff like this. No person may solicit or attempt a violation of any regulation. Again, just like basically nobody can violate it or help with it or so on. Conspire or act in concert with one or more other persons in any purpose that constitutes against violation. No person may, whether directly or indirectly, to any person make any false or misleading representational statements or clarification or pacify concerning any matter of fact in the course of the investigation. So they can't like lie about stuff while they're being investigated in connection with the preparation of report. So nobody can also engage in any transaction or take any other action with it to evade the provisions, so they can try to evade it. Nobody can fail or refuse to comply with any reporting or record keeping requirements or any regulation or direction mitigating measure part of a issue thereafter. So they just have to do what is they said. So if they were like, if they need to like argue orders in regards to it, they have to follow them. That's how laws work. They instead like you need to follow it. Except as specific authorized in the subchapter, any regulation and so on issued. Like any such direction, no person may alter any order, direction, mitigation measures, or authorization directive issued under this act or any regulation, so they can't like modify it. Continuation of effect for purposes of 2E. So this one, any like representation, statement, or certification made by the person shall be deemed to be a continuing effect until the person notifies the Department of Commerce or relevant executive department in accordance with the B. Any person who makes representation, statements, or certificates to the Department of Commerce or any official of any other executive departments or any other department, blah, 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 shall notify the Department of Commerce or the relevant executive department of agency in writing of any change of any material, fact, or intention from that person present. So, if they give information from the investigations, they need to like notify of things that change. Immediate operational information would lead a reasonably prudent person, big things again, to know that change of material, fact, or intention has occurred or may occur in the future. So if anything changes, they need to inform about it. So for violating this, the secretary can impose these consequences. A fine of not more than 250,000, or an amount that is twice the value of transaction. That is the basis of violation with respect to which penalty is imposed, whichever is greater. So basically, they can go above this if it's smaller than twice the value of transaction. Revocation of any mitigation measure or offers issued under the act of the person. Then the penalties. So anyone who willfully commits a person who willfully commits, if he attempts to commit, or willfully conspires to commit, or raises or aberts in the, so basically do this, shall upon conviction because no more than 1 million, or if the entire person may be imprisoned for not more than 20 years or both. So a person can be imprisoned for 20 years for this. Arbitrary is 1 million, which is nice. Still forfeiture, a forfeiture. In general, any property, real or person, intangible, used to be used in any manner to commit or possess a violation or violation is current paragraph 1 shall be subject to forfeiture. Proceeds, any property, real blah blah to the gross proceeds taken or obtained or retained in connection with or as a result of any violation shall be subject to forfeiture as well. Seizure and forfeiture on these subjections shall be governed by the provisions of Chapter 46, blah blah. Okay, that doesn't really tell me anything. Now, criminal forfeiture. So, yeah, these are civil and criminals. So, these are things that can happen to just a person. So if a person like who isn't like the one doing the thing breaks the act, then they can be charged these things. If the person if a person is actually actively is the one who's actually doing it, organizing the whole thing, breaking off the act, then it gets much worse. The criminal is I guess it's kind of the same thing in terms of what they lose though, beyond the actual punishment, that is. So juridical review, so classified information has to be in term. Yeah. Any information that transmitted it's classified information. Notwithstanding any other provisional law, actions taken by the president. Okay, this is very long. Actions shall not be subject to administrative review or judicial review in any federal court except as authorized by this section. No later 60 days after actions in 3A. Well, basically determining if it's wrong, or president taking actions. Somebody can apply for review by putting a petition, and then nothing get a review to happen. The court shall not disturb any action taken by secretary under 3A or by president under 3C unless the petitioner demonstrates that the action is unconstitutional or in pain violation of current mandatory statutory commands. So they need to prove that it's valid enough, I guess, to petition it. And then U.S. Court of Appeals shall have jurisdiction over these claims. So yeah, they can decide on that. The person is covered in such a petition. Okay, they apply petitions. Filing a record, they can apply. Okay, fair enough. All unclassified information contained in that record filed pursuant to paragraph 2, that is authorized spirits or subject to certain persons, shall be provided to the petitioner with appropriate protections for any privileged or confidential secrets and commercial information. In camera and expert review, the following information being created in the record and shall be sent only, or an expert and in camera. Says security information, privileged law enforcement information, okay, some stuff, acts, fair enough. Information under seal, and information is part of the record, file expertise, and Some record consistent with the provisions in section. Intelligence information released the picture as part of the public record. Return after the experts have time to seek further review or the conclusion of further proceedings. The court shall return the items to record, including any all copies to the United States. So not what they do to the documents and decide stuff, I guess. Nothing is limiting, suppressing, or parenting implication, or it's authorized by law, or blah, blah. Okay. So I guess people can try to get a review, but there's many, like, it needs to go through a lot to be accepted. Yeah, so this I think I don't understand, so I won't even read that. Okay, so much is applicable, yeah. Yeah, these are all about, like, acts. Yeah, so I think I pretty much, yeah, so if something is deemed, like, invalid, the remainder will not be affected. They are authorized to be appropriate in such yeah, whatever, legal stuff. So basically, it's a very vague, it's just like a very vague bill as a whole. I mean, I guess everything is on the vague side. But basically, it's saying that, from what I gathered, the secretary can decide that something is, like, dangerous. Then they need to go through, like, the constitution accordingly, and they need to go through the president. And if they also approve, then it's deemed to be harmful. And then they'll be an adversary country. And then the secretary can, once you have the country, the secretary can decide, okay, this thing is violent, this thing is like harmful, and they can then use that to, like as mentioned before, going through like the president, all of that. They can like decide it to also be adverse, and then once they decide that is adverse, they can just like investigate it, require witnesses, and apply relevant penalties and such if they deem it's broken. So the basic thing is that the secretary can kind of just apply this law to anything they deem dangerous, with some review steps. So there's no like specific thing has to be broken. It's just if some countries deem to be a danger to the US security, like China, then the secretary can decide that, okay, these companies or like these transactions from that country are like wrong their adversary, they need to be dealt with, and they can decide to apply consequences and such to that. Now, does this affect individuals? It can. It mentions individual persons. An individual person can be imprisoned. They can be charged a lot of money. But for the transaction, the product needs to be big enough for it to work. But what if you are not like the person like the company side? What if you're the customer? It doesn't specify you can't be the customer. So, it could absolutely be applied to people. Whether it will, that I didn't know. Very likely it won't, but it could be applied, and it has like, at least from what I can interpret, what I can see, it can be applied to people, which is kind of concerning. But also, it does look like it would be more likely to affect companies. So it can affect people, it can affect companies, but it has been claimed to be affecting like target towards companies, and whether it be applied towards individuals, I do not know. In any case, that's the stream. Hope you enjoyed, and see you in the next one.